Hey guys, welcome back. Joe Brunsman, insurance broker to the stars. And today, how about a very small, unglamorous data breach class action from an industry that people generally would never think would be subject to one, a data breach, and then two, litigation after the fact. Before we begin, real quick, CRD and Aston lawyers for the situation. If you need help with your MSA and want an attorney or xclause.com just for the MSA and the SOW. All right, now this is the case of Buckner versus, I left out their name, but they are a steel company. They just make and manufacture steel. So nothing particularly interesting, no, huge troves of PII, PHI, PCI. This isn't, Home Depot, it's not Target, it's just a steel company. And not a very big one at that. Now, class action, this was in a state court, which is important because the states have yet to really kind of like clamp down in the same ways that the feds have. Now, the defendant is a steel manufacturer. Only about 5,000 individuals actually impacted here. So that is not a lot. That is like the size of a small CPA company, or that is the size of, say, a dental office with all the records they have in their system. This is not a large company. Now, series of events. February 6th, intrusion got detected. Access window was only about 48 hours, which sounds like a lot in the grand scheme of things for a manufacturer. Lightning speed. Full scope of compromise. They said, hey, we think this is like when the forensics comes out, March 25th. So you go, all right, really quick turnaround there, all things considered. Compromised data, names, social security numbers, dates of birth, and driver's license numbers. Health insurance and health information. And you're probably thinking, okay, why would a steel manufacturer have this? Well, it belonged to the company's own employee health and welfare plan. This was not customer data. Now, if I were a betting man, if I could go back like the day before this event occurred, if I would have sat down with the CEO and said, hey, you have a huge potential problem here. You could be facing a data breach and you could be facing, a class action claim after the fact, all this negative publicity and all this stress, he probably would have laughed at me because he would go, hey, I am a steel manufacturer. What could they possibly steal? Maybe ransomware. Okay, we'll deal with that. But a class action claim in 2025, that's insane. Well, they got hit. So this is what the allegations were that were made by the plaintiff. They said, hey, they failed to train their own employees on cybersecurity. They failed to adequately monitor vendors and suppliers handling this PII, PHI. And of course, they failed to maintain reasonable cybersecurity safeguards. Now, that is an entire presentation in and of itself. If you guys want me to make a video to really try and explain what does reasonable mean, why does it go above and beyond kind of like the standard statutory requirements, like it could go above and beyond HIPAA high tech and right safeguards rule and kind of all these things. What is reasonable cybersecurity? How does it impact industries that traditionally kind of have no cybersecurity requirements? Let me know and I'll make that video. All right, now 20 days later. So within 20 days of what I believe is the forensics report coming out and all the notice being put out there, class action complaint got filed. So that is with the quickness. Now, 67 days after the total event, so you're talking 2 months down the line, this possibly, I was thinking about this might have been faster than some of the impacted parties. These individuals even got their notification letter or had implemented their credit monitoring, which is pretty wild when you think about it. But what can we learn from that? It means that the plaintiff bar, they're watching all of these publicly available breach notices that are coming out through various state AGs, and they're probably just lurking those sites waiting for something to happen. Now, within 221 days after the complaint, settlement reached. So you're looking at about, 180 days? So 6 months from bam, you got hit to bam, you're going to be shelling out a whole bunch of money. So very, very fast here. Now the settlement, about 175 grand. That's what the attorneys are asking for from the judge. Of course, paid by the steel company. Not bad when you think about it for a day's work, because I only counted effectively 16 documents that got filed with the court. So not a lot of potential work for 175 grand. Now, 4K for the class representative, so Buckner, who was named, that's what's showing on the FAQ for the settlement website. And the remaining 5,191 people, well, there's kind of like various things they could do. You could go find the settlement FAQ online, but they'll probably just get 25 bucks because it looks like, if I'm reading it correctly, they don't have to provide any additional documentation. So what does this really mean? It means the attorneys got them. It means they're going to make way more than everybody else. And that's probably quite the high rate for billable hours there. Now, you also have to remember the steel company, what we're not accounting for, so it's not just 175K plus the 4K, plus potentially another 25 bucks or whatever. I think it's up to 1,000 if they provide additional documentation, which they may or may not do per person, but the cost of the initial event to begin with. So the attorneys, the forensics, business interruption, breach notification, credit monitoring, loss of reputation, all the internal costs, plus, which I think people never really think about, but it's something that being an insurance broker, I get to see this all the time, unfortunately. It's this stress, the stress on the business owners and the executives, and that idea of publicity, not particularly good. I've seen that really, really crush people. So you don't want to be in that particular train. Now, takeaway number one, boring industries. So for all my MSP clients out there, you're always thinking about, people with a bunch of medical information or people with a bunch of social security numbers, right? We all know what kind of the big regulated industries are. But this just goes to show that just because you're in a quote unquote boring industry, you probably still have high risk data out there that somebody would be willing to sue you for if it gets taken. Now, remember, this was not customer data. This was employee data. All right. So employee data. Ergo, clients with social security numbers, health insurance, payroll data, you have a high potential liability there. It's a type of liability you probably never thought of before, but these data breach class actions are really, really picking up speed. So you want to make sure you're accounting for that. Now, treat HR and benefits data like gold. You want to provide additional protections on there. Takeaway number two here. Only about 5,000 people were impacted. Now, this might sound callous. I don't want to sound flippant, but that is teeny, teeny, tiny in the grand scheme of things. I have dealt with many, many orders of magnitude higher than that. 5,000 total people, that's nothing. That is not a big company. That is not a big data breach. And you can see, hey, if the attorneys are willing to put in the time to go after them, they might go after your business too. So litigation and settlement, that just happened anyways. So no, you're not too small. You're not too boring to get sued. If an attorney can make money off of you in this arena, they're probably going to try and make money off of you. Now, takeaway number three, fast response does not equal no liability. All right. So it's not just the response time that's important. It's also those reasonable cybersecurity controls are going to come into play. Like I said, I can make a whole video on that. It's an entirely separate topic on what that means. Now, you may be thinking like, oh, well, they were in there for 48 hours. Remember, this was a manufacturing firm. So detected the same day, contained within 48 hours. Manufacturer's average is 265 days. Oh my goodness. Now, some of that is because if you're a manufacturer, you're going to have these big, expensive legacy systems. If you're one of those guys, hey, go talk to your IT folks, talk to your MSPs on ways to try and isolate those systems as much as possible, because you're dealing with a whole bunch of infrastructure that is just not secured, and that is going to make everything infinitely worse. So they got sued anyways once that data was confirmed that it was touch. So yes, speed can limit the damage, but it doesn't necessarily prevent litigation. Your best way to prevent litigation is to prevent a data breach to begin with. So like I do jujitsu, and there's kind of this common trope where, right, somebody new will say like, hey, how do I get out of, what's the best way to get out of this submission? And we always say, don't get in that submission to begin with. That's the easiest way to do it, right? Don't leave your limb hanging out for it to get snatched. Frameworks are your friend. So if you're an MSP and you're watching this, please map your clients to a framework. If you're an SMB watching this, please map to a framework. Go talk to your MSP, talk to your IT folks, map to a framework. That is seriously going to help you here. Takeaway number 4. Hey, if you're an MSP, make sure your clients are aware of this totally unglamorous case. So this was a steel company. If they're in an industry like healthcare, like financial services, they are absolutely a target, and they are more likely to have higher volumes of this sensitive information than a random steel company would. So yes, they're absolutely a target. If they have PHI, PII, PCI, they're going to be in the crosshairs there. Now, as an MSP, hey, who owns incident response? Make sure that that's ironed out in writing beforehand. Please contractually require your clients to carry cyber insurance. All this money has to come from somewhere, and you don't want it to be your MSP's tech E&O policy. Make sure you have your MSA and your SOW up to date. There's a whole another video. Eventually, I might make a video just kind of going through the big ticket items in MSAs to give you the plain language understanding on why that's important. But suffice to say, when we're talking about many elements within your MSA and your SOW, that could be implicated. So you don't want to be paying because a client is getting sued. All right, with that, that was a short one, 12 minutes. Man, that might be a record for me. All right, guys, like, share, comment, subscribe. Let me know if you want a video on either MSA, SOW, just kind of pouring through, telling you what all of these things mean, and or if you want a video of me talking about what reasonable cybersecurity safeguards actually entail. All right, guys, if you click above me, the evil algorithm will recommend another video for you. And if you click over there, you can subscribe to my channel. All right, guys, with that, stay safe.